Today I'm going to talk about reasons for contesting a will. There could be a number of reasons for contesting your will. Firstly, the fact that the deceased never had testamentary capacity. Testamentary capacity is a requirement that needs to be complied with at the time that the will is prepared and subsequently executed. The second reason for challenging a will sometimes includes also the issue of whether or not there has been compliance with the requirements under the Wills Act 1837. Sometimes the other reason for challenging a will can be on the basis of undue influence, allegations of fraud and or forged wills. Now this is a minefield, and the reason why it is a minefield is because they require a higher burden of proof, and the onus is upon the person who is challenging the will to establish that they are correct in their analysis that this will is a forgery, or that it has been fraudulently procured, or that influence has been exerted over the deceased. The other reason for sometimes challenging a will is lack of knowledge and want of approval. Now, it's a technical term, but technically it means literally what it is. The fact that the deceased did not understand what he or she was signing at the time that the will was executed, or didn't have an appreciation of what they were dealing with at the time that they signed the will. There is also sometimes flaws in a will that has been prepared, and the beneficiary can challenge a will on the basis that there is a flaw in the will that needs to be rectified. And sometimes it's simple things in respect of a trust. It could be that details have been incorrectly recorded, and therefore you can make an application to rectify the terms of the will. Usually the people that challenge a will are either individuals who fall within close or direct family relatives. Could include a spouse, former spouse, children, illegitimate children, adopted children, children who have been provided for by the deceased at any given one time when the deceased has been in a relationship. And also there are also individuals who have been financially placed reliance on the deceased in providing assistance during the deceased's lifetime. In order to bring a claim for a contest against a will, the usual format would be for the person who is challenging the validity of that will is to enter a caveat. A caveat is a document which prevents a person from applying to the probate court for a grant of probate. And it's usually the executor who will usually apply for this, and that will prevent that proceeding. But at the same time, the individual who's challenging the terms of the will have to set out their case in clear terms as to the basis of doing so. This claim must be brought within 6 months, or as soon as possible, as reasonably practically possible, in order to bring a claim. Even if a grant of probate has been granted, you can still bring a claim under Section 1 of the Inheritance Provision for Family Independence Act 1975, provided you fall within the category of individuals who can bring a claim. Timescales in usually completing these type of claims can be quite substantial and cumbersome, because it will be an exploration of the deceased's lifestyle, what he or she was doing. You will also, if you're challenging on the basis of capacity, will have to consider securing medical records of the deceased in order to ascertain whether or not the person or individual had any issues of any type of impairment. Costs can be very excessive on these type of claims, and it depends and varies as to the approach that's adopted by your opponent. But with these type of family disputes, it is encouraged by the courts that there should be some sort of mediation or alternative dispute, and that can bring, hopefully, a fast and efficient conclusion to the claim. Unfortunately, there are occasions where you will have to go to court, and if you do need to go to court, proceedings are relatively straightforward, as this will be dealt with under the probate jurisdiction and will be dealt with in the Chancery Division of the High Court. But the claim form and the documents are relatively straightforward, as this is dealt with under a Part 8 procedure.